I'm doing excellent. Good to see you, brother.
Please make sure your phones are on silent.
That's my friend's. That's my brother. That's like very. That's old pictures.
All right, good morning, ladies and gentlemen. Welcome to Senate Judiciary. We've got several matters set on the agenda today. Before we get started and before Ms. Ogden calls the roll, I want to tell you, if you're here on HB 3, that's been set for a public hearing, you're welcome to stay, but that bill is going to be carried over. So if you're here specifically for HB 3, and that's Representative Chip Brown, that bill is going to be carried over. All right. Also, we've got, looks like HB 202. We were going to move that up and have the public hearing on that. We will not be taking a vote on that, and we will not be taking a vote today on HB 42. Both of those are public hearings, and we will consider voting on those next week. So we're going to move HB 202 up, and is Representative Reynolds here? Mr. Chairman.
You want me to call roll?
Yeah, Ms. Ogden, if you'll call the roll for me.
Senator Allbritton? Here. Senator Bell? Here. Senator Carnley? Senator Coleman Madison? Senator Elliott? Here. Senator Figures? Here. Senator Gavan? Here. Senator Orr? Senator Singleton? Senator Smitherman? Here. Senator Stutz? Here. Senator Weaver? Senator Barfoot?
Here.
9, and we got a quorum.
All right, very well. Representative Reynolds, Mr. Chairman, if you want to go ahead and start and tell us about the bill, and then we'll get into the public hearing portion. And speakers, it looks like we've got 3 folks signed up as opponents and 1 person as a proponent of the bill. We're going to try to limit conversation or your remarks to 3 minutes each. We'll give a little bit longer than the normal 2. Representative Reynolds, Mr. Chairman.
Chairman Barfoot, thank you to the committee. Appreciate you considering our bill this morning. HB 202 updates the current statute, Alabama Code 13-327, clarifying when an officer has immunity, and just as important, if he or she acts outside the scope of their duty and does not have immunity protection as described in this bill. I think that's just very important based on a lot of the stuff I'm hearing. The current statute has not been updated since 1979. There's a lot of old verbiage in this bill. I mean, even I think back about the fleeing felon law was still in this bill, where an officer could use deadly force against someone fleeing, but maybe didn't pose a threat to the community. So certainly that needed to be updated in this bill. This bill would also align the state statutes with current case law, 2 Supreme Court cases, Tennessee versus Garner, and also Graham versus Carter. And that's what's currently being taught in our police academies today, certainly in line with that, and should be. Here, to me, is the core of the bill. Law enforcement officers who use force constitutionally while carrying out their duties are immune from prosecution. Law enforcement officers not immune for any unconstitutional use of force during any execution of duties. If it's unconstitutional, they have no coverage under this piece of legislation. Therefore, unconstitutional uses of force remain prosecutable to the fullest extent of the law. The bill on the criminal side would entitle a law enforcement officer to a pretrial hearing to establish the applicability of the protection. The bill would provide an automatic stay for any prosecution while the law enforcement officer seeks to establish the protection applies. What I've also heard is this is going to make it harder to arrest police officers. That's not true. Typically, when this occurs, an indictment or arrest of a police officer has already occurred. And certainly applaud some of the Democrats that probably spent over 4 hours with me on this piece of legislation, and the attorneys from the governor's office in Aaliyah. And they came up with a great amendment. They felt like that should happen within 45 days in case there's unrest in the community or unrest within the department. You would know in 45 days the judge makes a ruling whether that officer has protection under this bill or not. Simply said, I just simply believe that our men and women of law enforcement deserve this stay in this criminal prosecution and also civil to make that determination. You know, oftentimes they make this decision on their discretionary authority within seconds when an incident happens, and the least we can do is pause that. While I've tried to get through this bill without talking about any specific cases in Alabama, and we've done so to date, and I don't want to do differently today. But there's recently been a case where an attorney representing a police officer asked for a hearing, and he received that hearing. And that officer found that he did not have immunity, and therefore that criminal case would proceed. That's simply what we're asking in this. Mr. Chairman, I'll be open for questions.
Thank you, Mr. Chairman. Let's do this. We're going to get into the public hearing. If you don't mind sticking around,
Sure.
Obviously, for a few minutes, and let's hear from some of the public comments, and then we'll come back. I think members may have some questions. First up, as an opponent, is Jita M. Smith. Ms. Ogden, if you'll set the alarm for 3 minutes. Ms. Smith, welcome to Senate Judiciary, and thank you for being here. We got a timer on you. We'll let you know when it gets 3 minutes.
I'll do my best.
Thank you.
I'm Gita Smith. I live in Montgomery, and most of my life I've been a newspaper reporter or editor for the Atlanta Journal-Constitution or the Montgomery Advertiser. And I've seen quite a lot of bills come through here over the years, and I find this one of the bad ones. This room, I believe, is where this bill should stop for a number of reasons, but although you can make the argument that it was discussed here, it was poured over by our lawmakers, the impetus for this bill comes from an organization called ALEC. ALEC stands for American Legislative Exchange Council. They're far away in Colorado and Virginia, and they have an agenda, and they have sent this bill or bills like it to 25 different states. This bill moves the needle closer to something that could be very dangerous. A police state seems far away to us, but police states do not happen overnight. They happen by increments. You allow a little of this, you allow a little of that, you exempt people from prosecution, you exempt the president from prosecution. Ron DeSantis was just arrested for embezzling $10 million. Should we exempt him? I think what we have to look at is where we're moving. What direction are we moving in? We do not want to create more situations where more boots go on the necks of more George Floyds, where a police officer kills the father and then there's no civil recourse for the family later on to ask for funds to help the family. Someone is shot in the spine accidentally. It was done constitutionally, as you say, but that person is crippled for life and cannot earn. Can that family sue for civil damages? Please take a step back. Please slow down from this bill and consider what happens if the needle keeps moving and moving and moving. You end up with East Germany and North Korea. Thank you.
Thank you, Ms. Smith. Thank you, Ms. Smith. Next up, we have Travis Jackson is an opponent. Mr. Jackson, welcome to Senate Judiciary.
Thank y'all. Thank you all so much. My name is Travis Jackson, and I'm a concerned Senate District 30, Alabama's citizen. I am an Iraq war veteran, and I am a racial justice advocate from the Alabama Equality Advocacy Committee. I am opposed to House Bill 202. I have several questions regarding this police immunity law proposal. My questions are, if an unarmed person was facing a mental crisis but forcefully taken down leading to deadly force, then will that law enforcement officer face criminal liability? Why are lawmakers not developing reprimands towards law enforcement's malicious use of federal investigative agencies? If a law enforcement officer intentionally uses non-lethal weapons towards unarmed prisoners, such as batons and tasers, then what will the officer be charged with? If a law enforcement officer is unlawfully on residents' private property, but that unarmed resident feels threatened, then will that resident face criminal charges for exercising self-defense? Will victims of police willful misconducts be eligible for compensation? House Bill 202 is the fatal opposite of the protect and serve slogan. This bill will increase disrespect and hurt towards disenfranchised communities such as African Americans, unhoused citizens, non-Christian faiths, LGBTQ plus people, people with disabilities, veterans, and immigrants. Law enforcement agencies will have a jail-free card due to not being held accountable for their criminal mischiefs. Samuel Sing Yang, an African American policy analyst, once said, "A police officer in America faces a 1 in 1,000 chance of ever facing jail time for killing another human being. Therefore, I strongly urge you to join me in opposing House Bill 202. Thank you all.
Thank you, Mr. Jackson. Next up, Mr. Jerome Dees is also an opponent. Mr. Dees, welcome to the Senate Judiciary.
Good morning, committee members. I'll be brief and we'll just focus specifically on the language so as not to repeat anything that's already been said. There are a couple of questions that I have. both in the civil prosecution application as well as the portion of the language that deals with the criminal code. Dealing with the civil prosecution aspect, the significant expansion of protections under the guise of scope of employment, expanding what that discretionary authority is particularly concerning. Page 3, lines 50 through 60, and page 15, lines 357 through 367, which indicates discretionary authority expanded to include not only the outer perimeter of law enforcement officers' governmental discretion, but any actions, whether constitutionally proper or not, were reasonably related to those duties. So expanding beyond just the constitutional protections, but anything that is remotely related to whatever action that officer may have been engaged in, based on the reading, would fall under those protections. Moving on to the criminal section, particularly concerned about the change. Current code requires reasonably required use of non-lethal force in effectuating an arrest for misdemeanor or violation, whereas reasonable use of lethal force is allowed for limiting effectuated felony arrests. What HB 202 would do is change that requirement and remove the distinction between misdemeanor and felony use of force. As I stated, I'll conclude my remarks there because it's already been touched on. The impact that this would likely have as relates to trust between the community and law enforcement. I hope that you all will take your time and properly deliberate this. Thank you.
Thank you, Mr. Dees. Always good to see you. All right, next up we have Hoss Mack with the Alabama Sheriff's Association as a proponent. Sheriff, welcome to Senate Judiciary.
Good morning.
Good morning.
It's a pleasure to be with you here today, and I thank you for allowing a public hearing on this matter. I want to personally thank Representative Reynolds for bringing this legislation forward. I stand before you today representing the sheriffs of Alabama as well as other law enforcement as we ask for you support on this bill to move it forward. We have been in constant work with ALEA on this as well as some other law enforcement counterparts in addressing this piece of legislation. HB 202 is offered to amend certain laws, as you've already heard, that were last updated in 1979. It defines the definitions of use of force incidents involving law enforcement in line with current federal law and United States Supreme Court decisions. In amending these laws, it will also align what is already being taught in our law enforcement academies across this state. This is of equal benefit to law enforcement and the public. Let me reiterate what this bill does not do. It does not give blanket immunity to law enforcement. It does not prohibit civil actions by victims of law enforcement misconduct. It does not remove appellate or judicial review or rulings or cases. It does not protect unconstitutional acts. This bill will provide due process of law for law enforcement, the same as any citizen of the state of Alabama. It is basically the same as stand your ground law. As already stated by Representative Reynolds, and I think this is a key component in this piece of legislation, is it removes the fleeing felon provision from the 1979 amended law, which is very necessary. It places the burden of proof for justifiable use of force on law enforcement officer to assert being immune from criminal prosecution through a hearing. In essence, this will expedite the process, and I do agree with the amendment on the 45-day provision. I think that people should have an expedited process through the judicial process in matters of use of physical force and certainly in those of deadly force. I was sheriff for 17 years. I have 39 years in law enforcement. When I started working on this and I heard the mischaracterization of this, that this was a license for law enforcement officers to do more harm. It was a license for law enforcement officers to use more deadly force. I couldn't disagree with those comments more. As a law enforcement officer in my career, I believe I set a standard and I saw others set the standard to hold law enforcement to be accountable. Personally, I've arrested police chiefs. Personally, I've arrested people that were in the discharge of my own office for acts of wrongdoing. Law enforcement should be held accountable. But this bill is necessary to support law enforcement.
Thank you. Thank you, Chief. Sheriff, you didn't. I know you didn't hear it. I didn't have it up loud enough. So, but thank you for coming and thank you for your comments.
Thank you, sir, for the opportunity.
Good to see you. All right, members. I know there's probably some questions. Mr. Chairman, if you want to maybe field some of those questions. Senator Smitherman, then Senator Govan.
Thank you, Mr. Chairman. Thank you. First, I want to say to Mr. Chairman that, and he can tell you that it's not any motive behind what I'm saying, but I want to say this to him. I think you do a good job as chairman. You know, I really do. You know, we've dealt on enough things that I want to say that publicly. Okay. But as it relates to this bill, in fact, I'm looking in our analysis, and I want to cite first the very obvious unintended consequences. I talk about those, but I'm going to just tell you my opinion about this. This is not intended. I'm not saying at all that any intent to the things that I'm saying what you bring in this bill. But it starts out as it's a green light for black folks to get killed. It's just the bottom line. It's a green light for black folks to get killed, and and person has the opportunity to not be held accountable. It does that. I'll just let me say it like this to you. There are very, very good officers, very good ones. There are officers who are afraid of black folks. You know, I'm just putting it out there for what it is. And there are officers who are biased against black people. You've got three categories. May have another category, I don't know, better or whatever. But those three categories exist. I don't know what numbers fall in those categories. I have no idea. But they do exist. And this law is going to allow the one that's afraid, and it's going to allow the one that's biased to open fire on somebody black. I ain't saying only black folks going to get shot. That's not what I'm saying. What I'm saying is that we as black people, and some of my colleagues have heard me say this, so for you it might be a first impression. We don't get the benefit of the doubt. I don't care what it is. Black folks do not get the benefit of the doubt. Okay, and that's the problem. If we wasn't dealing with that aspect, then you could probably look at it in a more favorable light. But that's the realities of life. That's just it. And because of that, this bill is going to cause a lot of black folks to get killed. And it's going to be done under the name of immunity. And that's unconscionable to think about. We are going to put our people in this state in a position that's going to take place. That concerns me. I just want to say that to you, to that level it's not good. It says in section, and I'm reading from our book, the analysis that we have in here. It says section 2 establishes immunity in favor of an officer from any claim that seeks to impose civil liability for conduct performed within the officer's discretionary authority. Discretionary. And put discretionary with them two things I just said, and the benefit of doubt is not going to go that way. The second thing I wanted to say that, and everybody who has talked to me about this bill has said what I heard you said as a positive for a fleeing felon. Well, I just want to make an announcement in here that's already been eliminated. Supreme Court eliminated that. See, so that ain't something that's we eliminating. It's already gone. Supreme Court ruled. I want to say there's no carrot trade-off that you're getting something for doing this, you know, and people have built it up like that. That's not the case. It's that doesn't exist. The third thing I want to mention is in Section 2D. It says requires a court to dismiss any claim against an officer in his personal or individual capacity premised on conduct within the officer's discretion. It go back there again. It just that whatever they said that was under his discretion. That whatever they said was that, then they're gonna get immunity because you got this buffer. You know, you got this bill. You got what happened. You got that look back or review. You know, I think you know what I'm talking about in here before it even gets to the court. And that person there, it ain't gonna never get to the court. This is very, very serious about the detriment that this is going to happen to citizens in general and black people in particular. And it hurts me to think that this bill can allow African Americans, quote, black people, to be slaughtered, like animals, to be slaughtered at will. And that is unconscionable for us to think about allowing that kind of situation. So, yes, I understand your intent. I think if you look back at my record in this legislature over these years, I've been overwhelmingly supportive of law enforcement. I think any of them will tell you that. I just look at the record. But I cannot support a bill, and I'm about through, Mr. Chairman. I cannot support a bill that's going to allow black folks to get slaughtered. I can't do it. Thank you.
Mr. Chairman, quick response. And Senator Smith, you know how much respect I have for you. I think the second year I was here in 2019, you had been for a couple of years trying to get the police officers database passed through the House. And honestly, Senator Gavan reached out to me and said, hey, you need to reach out and work with him on this bill. And we did, and we passed that thing. So have respect for you. So related, I'm just gonna respect your thoughts about what you say related to African Americans being damaged by this. But I wore this suit this morning because the last 3 police officers I buried at Huntsville PD, I wore this suit right here. So I take what you said and I flip the coin, and I worry about that split-second decision they've got to go through. And what if they hesitate? And then what if they are killed? And then secondly, you talk about the unintentional aspects of this case. I mean, we've got to have that discretionary authority there because we have an escalation in force. So we train our officers. It was mentioned earlier about, verbal communications, non-lethal weapons, deadly weapons. But our officers have to escalate during that discretionary moment, sometimes in a second, to match what the suspect does that makes that officer feel like that he's in danger. And then again, I know you talk about them not being prosecuted. Remember, they're already arrested. They've typically already been indicted. So that process is already moving. We're just simply pausing it and letting them have a right just like any citizen would have. As I said, this bill's not even in place, and a judge just allowed. We're in the court system where citizens are allowed these hearings. So I respect your comments and your opinions, but Mr. Chairman, that's all I've got on that. Thank you.
Senator Gavan, and then Senator Coleman Madison, and I think Senator Albritton may have a comment or question. Senator Gavan.
decision. I really recommend that. It's an incredible thing to see and watch other scenarios where it can come up and where things can go wrong both ways. So I'm going to talk about an issue here on page 12. I mean, I understand where the focus of this is, but long ago, before I made my transition to real estate, I actually defended Huntsville police officers. And the last case that I handled and won summary judgment on for 2 officers that you knew before you were chief, this section here came into play because one of the issues was there was some case law out of Birmingham after a death where an off-duty police officer was involved. They weren't shooting. It was sort of the officer should have stopped the fight, and they were sued for that, and the city ended up getting sued, and there was a statute that was in basically to overturn that case law, and I used that statute to win that case. But and my focus was on the police officers in the city of Huntsville. I wasn't worried about the other provisions of the statute. I am concerned on line 272 and 273. I'm not worried about, and this deals with if you employ an off-duty police officer, you have to have insurance policy of $500,000 coverage, and the idea is that's going to take heat off the police department and the individual police officers if there's a claim. But the failure to do so, it makes liability for every employer. I get that. Every general partner of a partnership employer, I get that. But the next two give me pause. One is that it would impose liability, and I don't know that this is in current law. I mean, we'll look and see what current law says. I want to compare that. But it says every member of an unincorporated association. I don't think that's typically the way it is. And then it says every officer of a corporate employer. And I know every officer doesn't have liability for action of an employer. So that's something I'd like to talk to you about and talk to LSA about and see if we can come up with a fix on that.
Well, a couple of things. First of all, you know, and you're aware because you've been in that situation. So current policy with a lot of the major departments, and it's what we call a model policy, is for an officer to either personally have $100,000 in liability coverage on them, or if you hire an officer in a third-party off-duty capacity, that person has to name that officer within their liability clause. I applaud this. Actually, this bill was only written at $300,000. And the league municipalities and the cities and the Big Ten mayors came back and it was moved to $500,000. So we've escalated this well beyond what typical, and I've already heard from those departments because they're saying, you know, are you telling me if this passes, we now have to have $500,000? And yes, you do. $100,000 today, and y'all know better than I do, a lot of attorneys here. That's just not reasonable. But I think that's something that's very important, and as you know as well, FOP, a lot of your associations offer that to the members, being the police department and the sheriff's officers. So a lot of these have the liability insurance themselves. If they have that in place, they don't impose that on the employer. But again, you're a lawyer. I think if you hire a person and it's a contract, right? It's a contract, and they do something on your premises, you're liable anyway.
My issue is not having the insurance. My issue is not raising the insurance. My issue is violating basic principles of corporate law and corporate governance for liability purposes. The officer of a company, if I'm secretary of a corporation and the president doesn't get the right liability insurance, I shouldn't be liable for it. That's my problem.
Thank you, Senator Van. Senator Coleman Madison, then Senator Albritton.
Thank you, Mr. Chairman. Representative Reynolds, my concern with this bill is dealing with people with mental health, which is a growing issue. I've worn many hats, and one of those hats was trainer and facilitator for the City of Birmingham's Police Department in my capacity as ADA Compliance Administrator. And in that capacity, I trained all the rookie classes that came through. These were new police officers. And one of the issues that we talked about is simply because we're dealing with people with mental disabilities or disabilities as a whole. Looking at their policies, basically they address a person in a wheelchair. That's not the only disability. That's a physical disability that you can see. Oftentimes you cannot see tell sometimes if a person is blind or legally blind. They may be able to see and get about, but they are legally blind. But in their policies, you know, you're talking about restraining a person and a person resisting arrest. Well, if I'm deaf and I use sign language, I talk with my hands. So you're asking me a question and you're in my face, and you're asking me a question, which is kind of like the badgering kind of thing. We all know the routine that we go through. And I'm trying to answer you as a deaf person, but your policy says you handcuff a person behind the backs. I'm trying to talk with my hands. So in that police's opinion or looking at his discretion, the person is resisting arrest. It would appear the person is struggling when he's simply trying to talk. And so I do have an issue with this. And then you have people that are mentally incapacitated. And I can tell you, because I had a brother-in-law, I mean, I think I visited every lockup facility in Jefferson County that are around, especially in the western area and the county jail, because he had a mental problem. And I would get this call, Ms. Coleman, this is so-and-so from something. I said, okay, what facility is he in now? And again, you have these people because of a mental disability that they are locked up. But oftentimes, if a police officer does not understand that, and he's using his own discretion in a situation, it could turn deadly. The other thing he says, they match what the suspect does, and sometimes that's not always the case. I don't know if this really addresses, you know, are we talking about somebody with a deadly weapon or somebody that has something that is really threatening them? Again, in the case of a person with a mental illness, you would not have that, but you would have erratic behavior that might cause you to think that something is wrong. But if the person is not threatening or coming toward you, it seems like there should be some other way. But again, as Senator Smitherman says, we don't have to really assume that something will happen. We can all look at past history and see what has happened in the past. Again, certainly the case of George Foreman was one of those extreme cases, but not so much here recently. So anyway, for that reason, I have some serious concerns about it.
Like, I appreciate that question, and I don't remember the makeup of the committee then, but, you know, I sponsored the legislation on crisis intervention training. So we worked in the first year, we carried a legislation to double the amount of the training for mental health. You know, we had a stakeholders meeting when I first came down here, and I thought I'd be carrying nothing but law enforcement bills and criminal justice reform, and I can say that because I was a cop. But what I found out was mental health was having the biggest impact on law enforcement. So since that time, we've hired a full-time coordinator, as you know. I think the last numbers I've seen, they've trained over 2,400 municipal officers on how to deal with mental health and see those characteristics, and now expanded some work Lee Halsey did and those silent disabilities, as you referred to. So I think we're getting there. We're probably not where we need to be. We got to continue that and expand it. I know the Sheriff's Association came to the table. They wanted to mimic that same thing within their ranks. We have done that now, doing train the trainer. So we'll continue to do that training, and it's a tough issue. I agree.
Thank you, Senator Albright.
Thank you, Mr. Chair. Mr. Chairman?
Yes, sir.
Oh, on each end. I want to thank you for bringing this bill. It is about time that we statutorily came into mind with clarifying and the roles and where those split seconds decisions can be made. The aspect of having if you read the treatises, the legal treatises, whether it be Cranman or the host of other evaluations by judges as to the actions of police officers in certain circumstances going back decades, it does fill volumes. And putting the onus burden on a cop in a circumstance in the dark, in the rain, in the street, of making a decision of life and death, to sift through that in his head before he takes an action is unreasonable. This is the best effort I've seen in being able to bring some clarification because cops are there to protect and to serve. And every one of them that I know do a doggone good job. And policemen, unfortunately, have become, instead of being the fathers and mothers and the people that they are doing the job that they're well trained to do, have become targets and become hated. They are people. Errors are made. But the forces that we have now in blue are the best trained that we have ever had. They're the best qualified that we've ever had. They are vetted better than they have ever been. We have good people serving. We need to make sure that they can do their job and that they are protected because they're protecting us. Thank you for bringing this.
I concur. Thank you.
Thanks,
It sounds like a
Jerome.
motion, Mr. Chairman. I mean,
Well, we're going to thank you for being here today, presenting the bill. We're going, the public hearing has been concluded, and we're going to move on from where we are. Thank you for being here.
Thank you.
Next up is HB 265. Mr. Chairman, come on up. And by the way, the order of preference here today has nothing to do with seniority or who's more important. I just want you to know that he does have a pen, so that makes him pretty important, Chairman Reynolds. But welcome to Senate Judiciary.
Mr. Chairman.
Yes, sir.
I just wanted to duly note that I can't recall. I said I can't recall when we've ever been first.
Understand.
Not just you, but I mean, I'm just happen to be in it. That's all I want to say.
Understand.
Thank you.
Thank you. Mr. Chairman.
Thank you, Mr. Chairman, members of the committee, and I'm honored to be in front of Senate Judiciary today. And HB 265 was brought to my attention by my local DA and sheriff to help address a gap in the law. And there's currently no provision in Alabama law affecting where cases where an individual actively resists a lawful arrest and as a result causes injury to a law enforcement officer or an innocent bystander. This gap in the law means that officers who suffer injuries due to resistance are not adequately protected, and this bill would aim to do that. With this bill, resisting arrest goes from a Class B misdemeanor to a Class A misdemeanor. Resisting arrest while brandishing a weapon or the act of resistance causes an injury to another person becomes a Class D felony, and resisting arrest while using or attempting to use a deadly weapon or the person's act of resistance causes serious injury to another individual becomes a Class C felony.
Thank you, Mr. Chairman. Senator Van, then Senator Bell.
So I may need Senator Bell or Senator Smitherman to answer this question, but so I appreciate you bringing the bill, and I like what we're doing here, especially in terms of on the dangerous side of this. What my ignorance is what about on the lower end of this? If somebody just runs away, the police officers roll up and they just run, and I mean I don't know where that line is. I don't want just running in and of itself without causing any brandishing a weapon or anything like that to escalate, and so maybe that's a non-issue.
Well, I'd say, let me try to take a stab at that. That would not be resisting arrest. I think that would be attempting to elude, would be a different charge altogether. There'd be no physical contact there, so it's my opinion. Senator Bell,
right. I think you're right.
Senator Smitherman and Senator Bell agree with me, so I must be right. Even if I'm wrong, if they agree with me, I'm right. Senator Bell, do you have a comment or question? Motion for favor by Senator Bell, second by Senator Van. Senator Singleton, did you want to?
Yes.
Okay.
Well, I understand what you're trying to do here, but just like the last bill, I can't support this because I see this as a death sentence. Because most of the time when someone brandishes a weapon at an officer, that's a shot. They feel in danger. That's not an arrest. It's never something to resist because they're dead. We saw a gentleman in Minneapolis who said to the officer, I have a pistol, it's in my glove compartment, you want me to get my license, I'm gonna reach for it, or you can come in and get it for me. The gentleman decided to reach for it, the officer said, reach for your license, and once he wants to get it, He saw the gun and he shot the person. We assume that there's no bad actors out there. There are bad actors out there. And so this says to me that in my community, in my neighborhood, for black folk, this is a death sentence. We don't get that chance to brandish a pistol at an officer or charge at him with a weapon without being shot. That's very seldom that happens, that we get away with that. You know, I know that during the riots, a young man walked down the street during the George Floyd riot with an M16 rifle, white young guy walked down the street, pointed his gun at people, and the police did nothing to him. Guaranteed, had he been black, he probably would have been shot. It's a difference. It's a difference. This is a death sentence in my community for young people who are out there. If they resist arrest with a weapon, they don't get a chance to be charged with the D felon. They get a death sentence. The D is for death for them. For that purpose, I can't support this. I understand where you're going, closing your gap. It's a great, but if the results was different, then I could say I could support you. Thank you very much.
Senator Smithman.
You said in our community, Senator?
Yes, sir.
I'll say Main Street, Montgomery, because that's where I was stopped, right out there. Right out there by that service station, the new service station right out there. You come up to there's a gap and there's a light right there. That's where I got stopped. And it's the same thing he was saying. The difference is, unfortunate for me, it's the era I grew up in. I grew up when segregation was legal, when you want to think we were messed over. I grew up in that era. So I'm out there in the streets. I get stopped for no reason. I'm running 30 miles an hour on purpose because I see the officer. Okay. He comes up to the car. It's just like what he was saying about that man. He comes up to the car. He tells me, I'm dressed just like this. I got my Senate stick on the back of the car. He tells me, put your hands out. I put my hands out. I do what I'm told. I put my hands out. He said, now give me your driver's license. Same thing that man said. I said, officer, do you realize? I said it because I know. I know what's getting ready to go down So I said, officer, do you realize I've got a reach in my back pocket where it is right now? I said, you got to realize I reached in my back pocket to get my license. When I said that, he stepped back and had his hand on top of the gun. He didn't pull it out. He had it on top of the gun. So I asked him, what do you want me to do? He said, that split second y'all talking about, I gave him 5 minutes. And he sat there and thought about it. He took another step back and said, give me your license. One hand out, it's the exact way I did. He's standing over in the back, looking at my back. He did like this. I said, like this. Like this. Pulled it out. Here it is right in the same place it be. Gave it to him. Okay? My whole point I'm saying is this. Is that I could have been shot. Y'all would have had a moment of silent prayer for me in there. I could have been shot. That's what we're talking about. Then, of course, the officer, when he came back, I pulled out my Senate ID. I said, was I supposed to give you this? He said, yeah, you're supposed to give me this because you got immunity. Why didn't you give me this? I said, I'm getting back to what we're saying now. We won't get the benefit of that. I said, because if I had gave it to it, you would have said I was either been a smart or using my authority over you because you didn't ask me for it. See what I'm saying? So it's a catch-20 for me. I take it out, you're trying to be If I don't, then that's the situation. He took it, said that, and drove off. That's what we're trying to set everyone in here. And I'm going to stay senator. I'm 6 blocks from this place. Lord knows what happened in the scenarios we're saying there. So that's why I'm just saying to you, that's just the facts of life if you black. And I hear what people are saying, but all I wanted to say was this, and I'm through, Mr. Chairman. All I ask any of y'all to do, if you don't understand what I'm saying, just walk 1 mile in my shoes. Just 1 mile. You'll understand what I'm saying. Thank you, Mr. Chairman.
Thank you. We've got Senator Figures.
Thank you, Mr. Chairman. I agree with all that's been said by my colleagues because in Mobile many years ago was a 19-year-old young man named Michael Moore who was shot down and killed. And the officer said that he had shown a weapon. He didn't. He had on those big, loose shorts. There's no way a weapon could have even held in there. And the officer basically got away with it. So I know, and when they say black people have a worse experience with law enforcement, we're not just talking about white officers.
That's right.
We're not just saying it's the racial kind of thing of a white law enforcement person against a black person. There are incidents with black police officers too, as with the incident, I think, was it Tennessee, when all of the black, and even here in Alabama. But, I mean, not to that degree, but in any event, I'm always careful. I mean, nobody's life is worth more than the next person's life. I don't care if they are a criminal compared to a law enforcement officer. All lives are sacred. God made all of us the same and created us equally, but unfortunately, we're not treated equally. So I don't agree with that. And if it was going to be across the board, when they did something they weren't supposed to do, and the victim got all of the immunity and everything that they needed to get to make them whole again from losing that family member's life, you know, maybe I could look at it differently. But when it's just one-sided, I definitely can't go along with that. And I also don't like the idea of us always ready to assume that that person is guilty, especially when they're black. It just amazes me that when a lot of these situations happen and it's a white person doing the shooting, they can always shoot them somewhere where they're still alive. But when it's a black person, they're dead. And I did experience the assimilation at Jacksonville State University, and I shot and killed somebody. But he had a gun, for sure. And you're right, you don't know how you will feel, but I hadn't been trained. And that is the importance of having a well-trained, educated, on so many levels with so many different, as Senator Coleman Madison mentioned. It's just so many things that could happen, and it's just not worth it. Thank you, Mr. Chairman.
Thank you, Senator Figures. We've got a first and a second. Ms. Ogden, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison?
No.
Senator Elliott?
Aye.
Senator Figures? No. Senator Gavan? Aye. Senator Orr? Senator Singleton?
No.
Senator Smitherman? No. Senator Stutz? Aye. Senator Weaver? Aye. Senator Barfoot?
Aye.
8-4.
Thank you, Mr. Chairman. Bill's given favor report. Thank you.
Thank you, Mr. Chairman, members of the committee.
All right, next up, we're going to jump around a little bit more. We've got HB 42, and that's Representative England, public hearing.
No.
You've got another, have you got another committee? Okay. I wasn't aware that any transportation energy, I think, has been canceled. Come on up.
Thank you so much, Mr. Chairman and the committee. This particular senator has been on the struggle bus a little bit. You all know I've had surgery, so I made it on time today for the committee because I was number 3. This particular issue is such an important issue. This is probably the 5th year that you all have heard from me on this issue. 2 years when I served in the House, and this will be the 3rd time as a member of the Senate. And if you all will indulge me, I just want to read a couple of things so we're all on the same page about the importance of Senate Bill 254. Approximately 1 in 4 girls and 1 in 13 boys in the U.S. are estimated to have experienced child sex abuse. Approximately 60% of victims are abused by someone the family knows and trusts. 30% are abused by family members. In 90% of the cases, the perpetrator is known to the child, 59% being acquaintances and 34% being members. 82% of all victims are under the age of 18 are actually female, 82%. Females from the ages of 16 to 19 are 4 times more likely than the general population to be victims of rape, attempted rape, or sexual assault. Every woman that I know has some story that they can give you about something that they experience, including me. Underreporting, an estimated 30% of sexual abuse cases go underreported, indicating a significant gap in detention and intervention. Child Protective Services substantiates or finds evidence for a claim of sexual abuse every 9 minutes. Victims are approximately 4 times more likely to develop symptoms of drug abuse and 3 times more likely to experience a major depressive episode. And so oftentimes those kids end up being in the system, and taxpayers are having to help and support the trauma that has occurred against them. Survivors are approximately 4 times more likely to develop symptoms of substance abuse, 3 times more likely to experience a major depression, anxiety, PTSD, and impaired relationships. I had a survivor tell me in my office that every time she is in a situation where there is a sit-in-the-window air conditioner unit, it takes her right back to being 8 years old and the trauma that she experienced. Childhood sexual abuse is linked to increased risk of heart disease, obesity, and cancer in adulthood. Abuse can lead to structural brain changes, affecting areas responsible for memory, stress response, and emotional regulation. And in addition, there is I don't want to say an economic burden, but there is an economic cost, and I'll use a particular state. In Minnesota, the annual cost of sexual violent acts against children from the ages of 0 to 14 is estimated at $71 billion, accounting for 61% of the cost of all violent crime in that age group. And I wish that we had those solid numbers here in the state of Alabama as well. So these statistics underscore the urgent need for comprehensive legislation which measures and comprehensive legislative measures to protect children, to support survivors, and deter those perpetrators. And I've had various iterations of this bill to come before the committee through the years. And now I hope we're at the point to where we have a compromise bill that we can pass today. Survivors of child sexual abuse face an uphill battle, not only in healing, but being heard. And this is what this bill is about, giving them an opportunity to be heard. The trauma inflicted at a young age often prevents victims from coming forward until later years. That's why some of you have asked me the question, why are we extending this statute to the number that we're extending it to? But on average, survivors disclose their abuse at age 52.
And Senator Coleman, I just want to, I should have said this under, members, you should have a substitute. I think
Yes.
Senator Coleman Madison is going to offer that. Let's go ahead and Senator Coleman Madison offering the sub. I'll take that as a first. Members, are there a second? There's a second for the sub. What kind of roll do we have? Holly, if you'll call the long roll for us.
Senator Albritton, Senator Bell.
Aye.
Senator Cornley. Senator Coleman Madison.
Aye.
Senator Elliott.
Aye.
Senator Figures. Aye. Senator Gavan.
Aye.
Senator Orr. Senator Singleton.
Aye.
Senator Smitherman. Aye. Senator Stutz. Aye. Senator Weaver. Senator Barfoot.
Aye. All right, we're on the sub. Any discussion on the sub, Senator Singleton?
Move for favorable as a substitute.
Got a motion for favorable on the sub and a second.
Previous roll.
Any opposition
Previous roll.
using previous roll? Senator Bell.
Thank you. I know we worked hard on this bill.
Yes.
From where it started. I appreciate all the meetings we've had and the interaction and where we got to, and look forward to voting aye on this.
Thank you. And that was my intention to actually open it up and thanking all of the folks that have helped through the years. All of my people on this side of the room definitely have been champions for this bill for many years, but the chairman and Lance and Senator Gavan have really worked with me as well. And you weren't on that side of the room, Senator Figures, but you, let me tell you, you were included in the work that we've done through the years. But to again have also my Republican colleagues say, hey, let's sit in the room and let's see what we can do to get something passed. And I meant to open saying that. So thank you so much for your help in putting those there. And thank you, Mr. Chairman, for the meetings through the years.
Mr. Chairman, I just
Senator
want to
Figures.
thank you, Senator. Thank you. I just want to thank you, Senator Coleman, for being so persistent. And that's what you have to be.
Thank you.
And I can identify with you with trying to pass the Clean Indoor Air Act bill for years. So I just thank you for your persistence, and I would really like for you to share that study with me.
I sure will. Thank you. And I do have one of my survivor groups here, one of the survivors from the group, who has been here every single time this committee has happened and has testified. So I have to acknowledge too that Stuart Vance is in the room as well. And thank him for the work, because I would have never said yes to anything unless my group was like, hey, we're okay with it. This is a step in the right direction. So I want to say thank you to all of you.
Thank you, Mr. Chairman.
Thank you. Acknowledgement to Mr. Vance as well. He's been here. Mr. Vance, if you could just stand up and let the committee see you. Thank you for being here and the tenacity that you've shown throughout the years in pursuing this footstep forward towards justice. Thank you.
Yes.
All right. No opposition using previous role. Bills given a favorable report as substituted. Thank you so much.
Thank you all so much. Thank you.
All right. Next up is Representative England. This is a public hearing only. Representative England, if you will, tell us about HB 42. And welcome to Senate Judiciary.
Thank you for having me. House Bill 42 is a simple fix to a bill that we passed a few years ago, where 3 words were eliminated from the code section. It took out a part of, which meant that the only option available for someone who's bonding out of jail would be to pay the full amount. And practically, what that translates into is a large amount of money that would normally go to the court system. Instead of going to the court system, it goes to a bondsman. And ultimately, this benefits both parties, because on one side, the defendant will be given an opportunity to forfeit cash to the court system directly, which means that on the other side, the court system, in the event that that person doesn't come back, that money is forfeited and is oftentimes used to pay fines, court costs, and even restitution. But on the other hand, if you force everybody on a full bond amount to go get a bondsman, in the event that that person absconds or doesn't show back up, the likelihood is law enforcement retrieves that person before the bondsman does. But also, in the event that we get any money back from that, it certainly doesn't come from forfeiture hearings that happen across the state, because many don't. And oftentimes, our bonding companies aren't solvent enough to pay those obligations, so we don't enforce them. So generally speaking, the basic question we ask is, who would you rather get the money? Would you rather the money go to the court system or go to a bondsman? So with that, I'm here to answer any questions.
Let's have the public hearing portion, and I actually had the public hearing sign-up sheet pulled, I think, before some folks came in. Are there any proponents of this bill that would like to speak? If so, would you raise your hand and let us know that you're here? Are there any opponents of the bill that would like to speak? If you could come up and identify yourself, and did you want to speak on it? Okay.
Mr. Chairman, procedural, are we voting on this?
We're not, just public hearing only. If you would identify yourself with the committee.
Yes, sir. Good morning, and thank you for letting me be here today. My name is Chris McNeil. I'm the president of the Alabama Bail Bond Association, and thank you for giving me this opportunity to address HB 42 and what it will allow to give defendants the option to pay a percentage of their bail less the bail amount. We have been given the data from Alabama Administrative Offices of Court from Senator Barfoot, and we've been able to run the data and do the analysis from 22 and 23. We've also got information from Illinois and Yolo County, California, from the DA and their bail study out there in California, and a letter from the Tuscaloosa County Sheriff, Ron Abernathy, to prove the professional bail bonds, surety bonds, far outperform cash bonds in ensuring court appearances, minimal financial losses, funding of the courts, and protecting victims' rights. Court appearances, and these are based on the numbers from AOC. These are not our numbers. This is numbers from AOC. In 2022, 40% of cash bonds statewide failed to appear in court, while surety bonds only had a 16.5% failure to appear rate. Even with that 16.5 failure to appear rate, we're able to go out and retrieve those defendants and bring those in and reduce those numbers. In 2023, that failure to appear rate on cash bonds got even worse, went up to 43.4% in 2023, while surety bonds improved to a failure to appear rate of 14.7%. In Representative England's own circuit, Circuit 6 in Tuscaloosa County, cash bond failure to appear rates were even worse at 32.95% in 2022, and it went up to 52.76% in 23, compared to bail bonds in that same circuit that were at 19.64% and then reduced down to 15.76%. Cash bond forfeiture rates are 4 or 5 times higher, and some of the bondsmen rely on police to, and some people say that the bail bondsman relies on police to rearrest the defendant. That's not true. Professional bondsmen use their own resources to track down and apprehend most failure to appear defendants at absolutely no cost to law enforcement or no cost to the taxpayers, keeping forfeitures low and saving public funds. Third, and most importantly, the revenue that's generated from professional bail bondsmen, a $35 fee is paid on each bail bond that a professional bail bondsman does. Those entities are divided up and paid out. That money goes to the clerk's office, the DAs, the sheriffs, police annuity, and forensic science. In 2022, we generated $3.49 million. In 2023, we generated $3.6 million in those $35 fees.
Mr. Chairman.
Thank you. Let's, if we could, hold the comments out to the public, and then we can bring him back up in just a second. I know Mr. Dees is here, and he would like to speak as a proponent. Is that correct, Mr. Dees? That's correct, Mr. Chairman.
I may forget what I had to say.
Yes, ma'am.
I said I may forget what I had to say.
You go right ahead and say it.
I just really wanted to make a clarification between what he said and what Representative England said. And I think he said that people say, and I don't know if he was referring to what Representative England had said about they depend on the police to arrest the people, but I thought I heard Representative England say that usually that's what happens. Not that they depend on them, but that's just how it ends up happening. So I just wanted to make that clarification.
Keep that question in mind, Representative England, when you come back up, if you will. You're welcome. Mr. Dees, welcome back.
Senator Figures, that's actually a perfect segue into what some of my remarks were. So prior to my current position at Southern Poverty Law Center, he's speaking as a proponent of the legislation. So prior to taking on my current role at Southern Poverty Law Center, my very first job out of law school was as a district attorney, both in Jefferson County, being recruited by Danny Carr, and a brief year here in the Montgomery County circuit under initially D.A. Ellen Brooks and then Darrell Bailey. And part of my role was kind of a unique position, not just a traditional circuit court trial attorney, but I was specifically in charge of forfeitures, both civil asset forfeitures as well as bond forfeitures. And part of my duties within that were actually looking through, combing and seeing if there were any outstanding FTAs, as well as looking at the surety amounts for the various bail bonding companies within the respective jurisdictions. The vast majority of times when there was an FTA that was actually ultimately secured and the defendant showed up in court, it largely was due to law enforcement bringing that individual in and not the bail bonding company. That's not to say that it never happened, but the vast majority of time it was law enforcement bringing that particular individual in. Secondly, to point that Representative England brought up. The vast majority of the companies that I was looking through their respective records on the total number of bonds that they were assured on versus the amount of surety and escrow that was put up was far exceeded. I believe that's what Representative England was referencing as far as the actual forfeiture hearing that takes place. A lot of these companies would end up going bankrupt if you called on all of what they are extended to. Oftentimes what you see, whether it's in municipal court or district court or even circuit court, you have a significant aggregate of the $1,000 bond amounts, the $2,500 bond amounts that add up significantly beyond whatever the $25,000 or what the current code says that they have to be escrowed on. At the end of the day, what we want to make sure is that public safety is ensured, that the court system is able to continue running. What this bill does is ensure that defendants who are, for the vast majority of them, these are going to be low-level violations, low-level misdemeanors, are able to put up some degree of funding that is going to go directly into the court system, that is guaranteed money. And the vast majority of judges across the state, because I not only practiced as a DA, after that I was in private practice in the vast majority of jurisdictions in the state. A lot of judges are actually engaging in this practice already. What HB 42 largely does is just codifies what judges are currently doing because they understand that that's how the system needs to operate to move forward.
Thank you, Mr. Dees. Representative England, I think there's some questions, maybe comments. I know Senator Bell had a question or comment, but I'd like for you to maybe address Senator Figures first, and then Senator Bell, then would be Senator Smitherman.
Just overwhelmed by what I just heard. First and foremost, the bonding companies under current statute, because we removed the a part of language, actually now have power that the judges don't have. Oftentimes when we talk about public safety, bonding companies will have a bond and then take partial payments from a family to make that bond up, which effectively lowers that bond. So aside from the fact that we're not getting any resources from that defendant, bonding companies are effectively lowering bonds without a judge, a court system, or anybody else being involved in that. Also, I'm glad he mentioned Tuscaloosa County, because the second part of what he didn't mention is when you don't show up, when you have a cash bond on the book, guess what happens? The money goes to the court system. And oftentimes people don't come back because the cash bond that's taken from them will often cover their fines and court costs. So they're not required to come back. Many people don't show back up because their case is closed. But also, you could come to court and get that money back if you'd like and set up a payment arrangement. But most people don't, because once they pay that cash bond, it covers their fines and their court costs. And the District Attorneys Association voted to support this legislation for that reason. Oftentimes, especially on cash bonds on traffic tickets or lower level misdemeanors, that'll oftentimes be the only money they get from a defendant to satisfy their monetary obligations. So, and as far as, oftentimes when over the weekend, Tuscaloosa is an exciting place on football game weekends, let me tell you, especially on LSU weekend.
Tennessee.
We would oftentimes, when people were arrested on the weekends, we would find out when they came in before their 72-hour hearing before bonds to find out that most of those folks were out on bond from on a bondsman. So they didn't discover where their client was until we did. And that often happens. And I don't really understand why they keep bringing up California and Illinois. This is not a situation where we're not requiring bonds or reforming the bond system. What we're trying to do is restore what we have been doing in Alabama for hundreds of years, which is allowing judges to issue partial bonds. And the last thing, and I've been waiting for years to talk about this, but he brought up the $35 bonding fee. Unfortunately, I've been here long enough to have been a part of that terrible piece of legislation, okay? The bonding companies, while they celebrate paying that, have been fighting it ever since. They've sued several times to get out of it. They're trying to figure out a way now not to pay it. So to use that as an example of what they're doing for the court system is just disingenuous at best. But, you know, he could have saved us a lot of time by saying this bill hurts my business. And I think that probably makes more sense than anything else he said. But anyway, I'm here to answer any questions.
Senator Bell, then Senator Smitherman.
I believe in judicial discretion. I believe judges should have discretion. And I appreciate there's a lot of bills we see that come before us that in the practical world, it don't work. When I read this, it was obvious this is who prepared this is someone that has been in the system, understands the system, and is putting into law what's already happening. Yep. And thank you. From someone that handles a lot of municipal court and is involved in the court system, we're already doing this. Yeah. People are not coming to court. People are, I mean, there's more FTAs now than there are anything. And if someone comes to jail, we do a cash bond, someone comes to jail, I'd rather the judges say, you know, well, my family can come up with $500, they can't come up with $1,000. We're already having hearings, okay, if they'll pay that $500, that wipes out the fine, that wipes out the court cost and all that, and they're done. They don't have to come back. We're already doing this. So, you know, I wish we was voting today because next week I want to do the favorable. But thank you, because this is what practically we're doing every day, and it makes sense.
Senator Smitherman, then Senator Stutz.
Thank you, Mr. Chairman. First, on the upside, I want to thank you for your dedication to these issues. Since I've been in the legislature, you have been really a person who has been focusing on these different issues. I think that it's probably unintended, not just by you, but just by things that have been said by several people that may be a little misleading unless you're up to speed in what takes place in the courts and the law. If a judge sets a bond for $500, it doesn't matter that the bondman take $25. The bondman is responsible to the court for $500. So the partialness about them lowering what they accept has nothing to do with what the court is requiring for that person to be responsible in that bonding company. The second thing is that although there are people who can come in with cash bonds, there are some people who ain't got the money. And if you got a $500 bond, and if they charge, I'm just going to pick, it's usually 15, I think, but they charge 10%, that person who can't afford can pay $50 versus having to fork up $500. The third thing is that you said it right about when you said what the man should ought to say. You know, yes, it's going to put many bonding companies out of business. It's going to be it's not going to be a competitive rate. They're going to charge excessively, the few that may be able to maintain. And that's just the facts of it. If a person can't get to a bonding company, they sure can't bond out. So I said those things simply because I've heard people talk about their experiences, but I say it because of my experiences as well. I was the clerk of for criminal district court for Judge P. Johnson, and before I became a lawyer. So I'm the guy that was over there. You understand what my role was and what we talking about. I'm the one that stamped the releases, whether they released from jail. I'm the one that had to follow through with the judge with forfeiting, whatever. You know how that is. We really did the paperwork. But the other thing is in conclusion about that is that the but the company in itself, they send out the bounty hunter to go get these people. It's not the police. The police department, sure, is a wanted person, but the primary function, because that bounty company don't want to have to pay with that large amount that the court is requiring them to. So they have a super incentive to go find this person and to go get them. So I had to just say that to you that I put you like this: as many issues as we deal down here, between about 6:30 and about 7:45, I got a few calls of concern on this issue, and I don't normally get calls like that in the morning, but it's just because those it's obvious things not intended, but we're gonna have a lot of these businesses that's gonna go out of business under this premises, not under one or two situations, but over the course of time. And I'm just gonna have, I'll just say it to you here, I'm gonna have to abstain. I'm not against what you're trying to do. I respect you and everything, but for the reasons I just mentioned, the bill itself, and it's not you, but the bill itself causes those problems, as I see it. Thank you.
And so I can respond respectfully. All bonding companies have been operating with cash bonds and parcel bonds forever. So restoring what we've been doing forever won't put anybody out of business because they've been already operating this way for years. The threat has been recently more people in the industry are threatening lawsuits because they don't want judges issuing cash bonds because they would much rather all the business be directed to bondsmen, which ultimately removes the discretion from the judges in the court system in determining who's worthy of a cash bond or not. So, and also, I want to respond to the lowering the cash bond because there's a certain amount, it's a percentage. You're supposed to pay the entire percentage, if I'm not mistaken, before that person can be released. Before that money can be put up for the court system to get that person released. We had a situation where there was a large bust in Tuscaloosa County where several people were taken into custody, and we actually had bondsmen in rooms offering lower amounts to each other to encourage one person to get this bondsman versus the other. Now, there was no discussion about anybody being worthy enough to getting out of jail earlier. This was them directly competing to see who could take the lowest amount to get that person out early. If we're talking about a discussion, I would much rather the judge be able to look at that person and assess them versus two people who are competing for business, lowering the amount that it would take to get them out to get their business. So when I meant that, lowering the bond amount effectively, because they're not putting up the entire percentage, they're going it on behalf of the person, but they're taking less of it. So that's what I meant. And as far as forfeitures are concerned, again, you're right. They do hire a bond retrieval agent, but oftentimes, and I've experienced this myself, this is what got me into this business, unfortunately, because I used to do this too. One of the things that happened in my court was a bondsman came off of a bond for a young lady because she refused to have sex with him. So they came into the courtroom, put her into custody, and pulled her out after she had already satisfied the requirements because she showed up to court, but she said, "I'm not going to have sex with you." So they came off her bond, took her into custody.
Seems like we've addressed some of that issue within the past year or two.
We're trying to, but instead of doing a lot of reform, we created the bail bonding sunset board,
right,
which is about 50-50 on it. But again, I'll just say this: the district attorney supported it, the court system supports it, the judges support it, all for the reason that, practically speaking, helps us retrieve some of that money, and it helps the defendant too.
Senator Stutz, and then we're going to wrap up the public hearing today.
Oh, thank you, Mr. Chairman. I just had a brief question. What is the reason for the huge discrepancy in the failure to appear rate? I mean, 2.5, 3 times difference? Are the bonding companies more selective in who they're willing to bond out? I mean, that's a huge difference.
That's part of it. And when you were, if you listen, like listening carefully to it, he was talking about sureties too. There's a difference between a surety and a straight up bondsman. But because there was also an idea years ago to go to just straight up sureties, because it's an insurance company behind that bond versus just a bondsman who's got $25,000 on the books. But the numbers are obviously going to be off because there are going to be more people on smaller offenses with cash bonds versus somebody who's on a large bond who's with a bondsman. So obviously there's going to be a higher amount of FTAs on smaller cases, on traffic tickets, for example, because they all count. Nobody goes and gets a bondsman on a traffic ticket. So the numbers are going to be skewed just off of that alone.
All right. Thank you, Representative Ingram. I appreciate you being here and explaining this to us. Members, no other business on the agenda. Senator Weaver?
So we had originally asked that we continue to work on HB 146. I think that we have worked out some of the issues that we were talking about, and if you're okay with going ahead and continuing that as the agenda, we will.
Well, I don't mind that. I mean, we'll take a vote of the committee, but I know Senator Orr's not here. Based on that assessment that I announced earlier, Senator Gavan, Senator Figures, I just told her that was going to be the end of it.
We'll just continue as planned.
Okay. Yeah, we'll carry that over and we'll see it next week.